Thank you. We will now restart proceedings and we will proceed with the division on Amendment 34, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 34 in the name of Rhoda Grant is yes 81, no 25. There were no abstentions. The amendment is therefore agreed. I call Amendment 35 in the name of Tim Eagle. Ready to debate with Amendment 34. Tim Eagle, to move or not move?
Not moved.
Not moved. We now turn to Group 3, Environmental and Other Purposeful Uses. I call Amendment 5 in the name of the Minister. Group with amendments are shown in the groupings. And I call on the Minister to move Amendment 5 and to speak to other amendments in the Group. Minister.
Thank you, Presiding Officer, and I move Amendment 5. Now, my amendments in this group will clarify the powers of the Commission when considering proposals by a Grazings Committee for use of the grazings as woodlands or for an environmental purpose. They also make technical modifications or changes that are consequential to the other provisions in this bill. So Amendment 5 corrects the reference to other useful purpose in Section 3AZA of the 1993 Act, inserted by Section 8 of the bill, so that it applies to owner-occupied crofts. Amendment 15 is a consequential to Stage 2 amendment from Tim Eagle, which I was happy to support. The landlord's deadline for responding to a Grazings Committee application is mentioned twice in Section 18, and my amendment changes the second reference from 6 weeks to 8, in line with the change that has already been made at Stage 2. My amendments 29, 30 and 31 are also consequential, because the bill gives tenant crofters the right to put their croft to an environmental use, and consequential changes are needed to other parts of the 1993 Act, which refers to the uses that a croft can be put to Section 30 on compensation for improvements, and to Section 58 on the Commission's decision-making, and Schedule 2 on the statutory conditions of tenure. The necessary changes are made by the amendments 29, 30 and 31 respectively. I am also very happy to support Alistair Allen's amendments 16 to 21, because these clarify important changes that the bill is making and make it clear that the Commission, not the landowner, has the final say on a Grazing Committee application for an environmental or forest use of the common grazings. Rhoda Grant's amendments 43 to 46 propose changes to the landowner's role in this process, and I am happy to support Amendment 46. It is right that the owner should be required to specify any conditions that they wish to impose and the rationale for them. But I can't support Amendments 43 to 45, which would reinstate 3 words that were moved from the bill at Stage 2 through amendments that I supported in the committee. Rhoda Grant's amendments would forbid the owner from refusing consent on the grounds of detriment or hardship or loss unless they were substantial, undue or significant. And I argued at the committee that these words were unnecessary because we are strengthening the role of the Commission. And the final decision in future will lie with the Commission, which will decide how much weight should be given to a decision to refuse consent on account of, for example, detriment to the management of the estate. And the Commission will, of course, set out its reasons for its decision on these applications. But we want that process to be, as far as possible, the standard process applying to all decisions, so that the Commission considers the wider public interest when taking a view on the balance of the benefits and the drawbacks of the scheme. Turning now to Rhoda Grant's Amendment 16A, this requires that in imposing any conditions of its own, the Commission must act reasonably and must set out its reasons for decisions, including why they are justified. And I think we all agree that the Commission should do that anyway. However, as a public body, there are already statutory obligations on the Commission to act reasonably and to communicate the reasons for its decisions fully. Duplicating those obligations in this bill would be bad law, and for that reason I would ask members to oppose it. Finally, Rhoda Grant's Amendment 47 would provide that the Grazings Committee should be entitled to all of the financial benefit from an approved crofter-led forestry or environmental initiatives on the common grazings. In respect of forestry, that would cut across the measures that are already in the bill that ensure that grazings committees will continue to have exclusive economic and recreational use of woodlands on their grazings. For the other environmental uses, it would sit uncomfortable with the new Section 50AA of the 1993 Act, which provides for grazing committees to be able, with the consent of the Commission, to enter into binding joint venture agreements with the owner of the grazings. I believe that the measures we have set out in the bill deliver the right balance, which will ensure crofting communities can benefit from environmental uses of common grazings, and we are committed, as a part of the wider review of crofting law, to carefully consider how natural capital markets can support vibrant crofting communities. And turning to the wider issues in relation to natural capital and financial benefits, these are issues which must be looked at in a wider cross-government space to ensure natural capital markets support vibrant crofting communities. And a lot of the detailed work in relation to the natural capital markets is ongoing right now, but it would be premature to set out in legislation at this stage how any financial benefit from a scheme should be shared between landlords and tenants. So therefore, I cannot support Amendment 47, and I move Amendment 5.
Thank you, Minister. I call on Rhoda Grant to speak to Amendment 43 and other amendments of the group. Ms Grant.
Thank you, Presiding Officer. I want to speak to Amendments 43, 44, 45, 46, 16A and 47. So, as the Minister said, the bill was amended at stage 2 to remove the words substantially, undue and significantly. And I wanted to see those words being put back into the bill because I believe that landowners can't spuriously stop developments on a croft. Now, that was before, obviously, I saw Section 50 is ZA, and given the assurances from the Minister, I don't intend to push those amendments. Amendment 46 adds a clause to the section: should the owner add conditions to consent for environmental purposes, they must specify why they are imposing them and why they believe they are reasonable. Again, with Amendment 16A, I have listened to what the Minister has said and I accept his assurances and will not seek to push Amendment 16A. Amendment 47. We in committee heard when we were taking evidence on the climate change plan that there was issues with progress, and there were questions about who was responsible for the environmental use of a croft, and that was holding back peatland restoration, for example. At the moment, currently, a crofter is entitled to cut peats and plant trees and cut trees on their crofts. Indeed, we have forest crofts. But there is a concern that if the crofter invests time, labour and finance into forestry or peatland restoration, the landlord will try and sell the carbon credits over their head. And this amendment therefore ensures that the financial benefit of any of the crofter's activity remains with the crofter. This is custom and practice, and it is wise to set it out in law. The landowner has no control over the peat or trees on a croft or common grazing, and therefore they can't take any benefit from that work because they have no idea what will happen to those trees or peat in the future. At stage 2 of the bill, the Scottish Government stated that there was a legal difficulty in including carbon credits in this legislation because it wasn't legally defined, and therefore this amendment doesn't use the term carbon credits, but it ensures that crofters get value from their endeavours. There's nothing in this amendment that stops crofters entering into joint agreements with a landowner. But the problem is where the landowner is not part of that joint agreement and does not want to take part, but is sitting back hoping to make financial benefit from that. So I believe that this amendment is necessary. I don't think this is something that should be set in the court. And crofting is different from other patterns of ownership in that the crofter is already entitled to the peat and forestry on their croft, and nobody else should be able to take that from them. So I will be pressing this amendment.
Thank you, Ms Grant. I call on Alistair Allen to speak to Amendment 16 and other amendments of the group. Dr Allen.
Thank you, Presiding Officer. I'll speak to my amendments 16, 17, 18 19, 20 and 21. Sections 50 and 50ZA of the Bill make changes to the regime for crofter-led forestry projects on common grazings and, importantly, also extend that regime to other crofter-led environmental projects. A system whereby the Grazings Committee has to get separate consents from both the landowner and the Commission is to be replaced by one where the Commission has the final say. The Commission must, of course, consider the owner's views, but alongside other factors such as the benefit to the crofting community and the public interest. In short, my amendments ensure that it is the Commission and not the landowner which has the final say on crofter-led environmental projects. Amendment 16 clarifies that the Commission has full discretion to substitute its own decision where it considers that the owner's original decision was unreasonable. And this applies whether the owner's decision was to refuse outright, to put conditions on the project or to approve it. Amendment 21 expands the list of factors that the Commission must take into account in reaching its decision, in line with the Commission's standard decision-making criteria set out in Section 58A(7) of the 1993 Act. This will now include the interests of the estate, the interests of the crofting community and the sustainable development of the crofting community, as well as such things as the public interest and any objections received. In addition, the amendment requires the Commission to take account of the owner's decision, including the reasons the owner has stated for any refusal. Other changes within Amendment 21 and in Amendments 17 to 20 are to remove duplication and to correct cross-references within the legislation.
Thank you, Dr Allen. And I call on the Minister to wind up.
Nothing further to add.
Thank you, Minister. The question is that Amendment 5 be agreed to. Are we all agreed? The Parliament is agreed. We now turn to Group 4 on common grazings. I call Amendment 6 in the name of Alistair Allen, grouped with amendments as shown in the groupings. And I call on Alistair Allen to move Amendment 6 and to speak to other amendments of the group. Dr Allen.
Thank you, Presiding Officer. I will speak to my amendment number 6, but I will start by saying that I strongly support sections 14A and 15 of the bill, which will prevent the further separation of grazing shares from crofts, something which has been an unfortunate consequence of the crofter's right to buy and detrimental to crofting. I will also support the Minister's amendments 7 to 14 in this group, which strengthen those sections still further. My own amendment 6 supports sections 14A and 15. Section 10A, which was inserted by my amendment at stage 2, gives ministers a regulation-making power under the affirmative procedure to make provisions about the transfers of owner-occupied crofts. My amendment 6 will make clear that power includes the ability to make provisions about the transfers of associated grazing shares, should it be desirable to strengthen or modify the regime which is set out in sections 14A and 15.
Thank you, Dr Allen. I call on the Minister to speak to Amendment 7 and other amendments of the group. Minister.
Thank you, Presiding Officer. I'm very happy to support Alistair Allen's Amendment 6 for the reasons he has set out. The link between owner-occupied crofts and grazing rights is a complicated matter where property law and crofting law intersect, and it's sensible for ministers to have regulation-making power in case the provisions relating to the grazing shares of owner-occupied crofters require to be refined in the future. Turning to my own amendments in this group, they also concern the connection between grazing rights and owner-occupied crofts. And this is one of these areas of law where the policy intention is clear and I think agreed by everyone involved, but where the means of achieving it is definitely not simple. A tenanted croft generally comes with an attached right to use the common grazings, and in legal terms, the grazing right is a pertinent of the tenancy. Our policy aim is that the grazing right should stay attached to the croft no matter what changes the croft goes through. The croft may be bought by its tenant and become an owner-occupied croft. It may then be bought and sold, and it may then even be relet to a new tenant. It may fall vacant and it may eventually be relet by the Commission. But no matter what happens to the croft, the policy aim is that the grazing right should, by default, stay attached to it. The only exception should be to that is if there is a specific application to separate the grazing right from the croft, and if so, that should be treated like any other application to divide a croft. The separation can only happen if the Commission consents, and the Commission will take account of the current and future interests of the crofting community, among other things, in their decision-making process. This is what sections 14A and 15 of the bill are designed to achieve. But because it's a complex area of law, the officials have drawn on advice from a small group of stakeholders and experts, many of them practising crofting solicitors, to look closely at these two sections of the bill. Now, I'm extremely grateful to those people for giving up their time to help us and to get this right. So my amendments at stage 2 and now at stage 3 have been informed by those discussions between my officials and that group of people. Amendments 7, 10 and 11 clarify the wording of the bill but do not materially change the purpose of the provisions. Amendment 8 removes from the bill a change we had proposed to make to the right to buy an apportionment. This was never a core part of the provision about retaining grazing rights with the Crofts, and following input from the group of advisers, I have decided it is best not to venture into this territory without further examination of the legal implications of any proposed change. Amendment 9 clarifies that when an owner-occupier croft is let, an attached share can have one of two legal forms. It also covers the circumstances where the owner-occupier crofter is letting only part of the croft. In that circumstance, they will be able to specify whether the grazing right is attached to the part that is let or the part that is not. This is, however, subject to Commission consent again. Amendments 12 and 14 clarify who has the right to relet a vacant grazings right. The Land Court has ruled that this should be the person who was the landlord of the inn by croft when it was a tenanted croft, or their successor in title. Sometimes that person is not the same as the person who owns the land over which the grazing rights are exercised, and sometimes, perhaps, after a passage of years, they cannot be traced. Our amendment follows the Land Court's principle whenever possible, but pragmatically allows the grazing's owner to take over the role if needs be. Amendment 13 allows a longer timescale for lettings of vacant shares to allow for the Commission's necessary exchanges with both the owner and the Grazings Committee. And Amendments 48 and 50, I'll take the amendment.
Just on the Amendment 13, it increases the time for the Commission to respond to 5 months, which seems... Can you hear me? It increases the time for the Commission to respond from 3 months to 5 months. I mean, people complain already that the Commission takes far too long to respond, and I wonder if you can give any assurance at all that people won't be waiting 5 months for a response from the Commission.
Minister.
Well, that will be for the Commission to make those determinations, and I hope that the Crofting community and Rhoda Grant and other members of the Chamber who have already engaged with what's happening will see that the Crofting Commission have sped up their provisions in making sure that they are getting their work done in a far more tedious way than has been done in the past. But turning now to Amendments 48 to 50, during the Stage 1 debate on this bill, there was a strong cross-party consensus on 2 points. Firstly, that the bill introduces a number of important and valuable crofting reforms, and secondly, that this next step needed must be a more strategic and fundamental review of crofting to identify a direction of travel for the coming decades. Now, this review will, of course, include common grazings, and I support that approach. And I will say more about that when we come to Amendment 26, which will commit ministers to a review of crofting legislation generally. Issues around common grazings are among the most important issues that the future review will look at. And I recognise the issues the member has raised, and I'm happy to support Amendment 50 that commits the next government to consulting on it. I thank Edward Mountain for his, I apologise, I should have said Amendments 48 to 50 are in the name of Edward Mountain. And I'd like to thank Edward Mountain for his contributions on this very important matter. And that's me, Presiding Officer.
Thank you, Minister. I call Edward Mountain to speak to Amendment 48 and other amendments of the group. Mr Mountain.
Thank you very much, Presiding Officer. And I'd like to start off my very short contribution to this particular group by thanking the Minister for taking the time to meet with me and trying to find compromise. Sometimes it's always not possible, but he's tried very hard in this, and for that I'm grateful, Presiding Officer. Can I just say at the outset, I am sad, however, we haven't resolved the issue of slipper crofters when it comes to common grazings. I think there's a real issue where crofters have moved away and sold their share in the common grazings to people who are no longer part of the crofting community. My amendments in this group, 48, 49 and 50, were to try and encourage the ministers to commit to a review of the operations of the common grazing. I wanted 3. The Minister wanted much longer, if not a figure on it. He's compromised at 5. I think that's a fair compromise. And the reason why I was pushing this, Presiding Officer, very briefly, is there are 1,078 common grazings recording in the Register of Cross, covering over 500,000 hectares of Scotland. Of these, only 461, less than half, have common grazing committees in place. Considering the amount and the importance that crofting will play in reaching net zero, which will be a high priority for the next Parliament, I think it's really important that we utilise those common grazings, and the crofters do to the extent they can, to benefit from them and for the country to benefit from them. I will say no more, Presiding Officer, to say that I will not be moving Amendments 48 and 49, and I will appreciate the support of the Government on Amendment 50.
Thank you, Mr Mountain. I call Ariane Burgess.
Thanks, Presiding Officer. I just wanted to speak to Edward Mountain's Amendments 48, 49 and 50. I think it's a really helpful step for everyone with an interest in common grazings that ministers must consult for better guidance on common grazings. And I think it's a useful backstop to the Amendment 26, which the Minister already spoke about, that we'll get to in Group 8. But the getting of the timing is right, and I really appreciate Edward Mountain going for Amendment 50, which is the one that the Greens are inclined to support. Thank you.
Thank you, Ms Burgess. And I call on Alistair Allen to wind up and to press or withdraw Amendment 6.
Merely to press, Presiding Officer.
Thank you, Dr Allen. And the question is that Amendment 6 be agreed to. Are we all agreed? The Parliament is agreed. We move now to Group 5 on resumption. I call Amendment 36 in the name of Rhoda Grant, group with Amendment 37, and I call on Rhoda Grant to move Amendment 36 and to speak to both amendments of the group. Ms Grant.
Thank you, Presiding Officer. Amendment 36, I move Amendment 36, and this amendment is similar to Amendment 188 from Stage 2 that was in my name. And this was submitted ahead of the new amended Section 50ZA put in by Alistair Allen, which does add protections for crofters. But I still believe that this amendment is required because resumption can take from a crofter their land and their work. And in order to do this, it surely must be in the public interest to do that rather than in the interest of the landowner alone and be resumed for spurious purposes. Amendment 37 is again similar to my Amendment 47 on financial benefit, and this amendment would protect crofters in a scenario where a landlord attempted to take back a croft in order to benefit from the financial gain arising from activities carried out on the croft by the crofter. And this could include things such as the sale of carbon credits, to give one example. It's very important that we protect crofting from the carbon market.
Thank you, Ms Grant. And no other member has sought to press, so I call on the Minister.
Thank you, Presiding Officer. I am going to ask Rhoda Grant not to press these amendments, but I want to begin by setting out some context as regards resumption, because current legislative provisions on resumption ensure that crofters are compensated for any loss of land, and they also entitle crofters to 50% of the value achieved by the resumption, and of course the Land Court can reject the resumption application, especially if it is opposed by crofters. Now, I am aware that there is renewed concern about resumption in the context of the increased opportunities and incentives from peatland restoration and tree plant Act, and I genuinely am, particularly from crofters who want to take forward these opportunities through grazing committees and joint ventures. But we are committed to ensuring that there is a balanced approach that protects both the rights of the owner and the crofter. And as part of the review, we will very carefully consider whether the law on resumption needs to be updated. But there are many resumption applications that are made with the consent of the crofter and for the good of both the croft and the crofter. If we were to simply prevent landlords from resuming land on the grounds that they may receive any financial benefits, which Amendment 37 would do, we will prevent crofters from receiving a share of the benefits of a consented project. So even if that project was to give crofters 80% of the financial benefits, Amendment 37 would not allow that resumption application to be authorised, and that's where the problem lies. I want to reassure Rhoda Grant and other members that I recognise and I have genuine sympathy with the issues that are raised, but I hope that she would accept that we should not be taking such a significant step without first considering all of the consequences and how that might affect not just the croft owners but the crofters. And that this is something that we will do very, very carefully as part of the further review.
Thank you, Minister. I call Rhoda Grant to wind up and to press and withdraw Amendment 36. Ms Grant.
Okay, I would seek to withdraw 36, given the reassurances that the Minister has put on the record that resumption won't be used against crofters and that they have adequate protection.
Thank you, Ms Grant. So Rhoda Grant seeks to withdraw Amendment 36. Does any member object? No member objects. Amendment 36 is therefore withdrawn. I call Amendment 37 in the name of Rhoda Grant. Ready to debate with Amendment 36. Rhoda Grant to move or not move?
Not moved.
Not moved. I call Amendment 38 in the name of Rhoda Grant. Ready to debate with Amendment 1. Rhoda Grant to move or not move?
Moved.
Moved. The question is that Amendment 38 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I call Amendment 39 in the name of Rhoda Grant. Ready to debate with Amendment 1. Rhoda Grant to move or not move?
Moved.
Moved. The question is that Amendment 39 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I call Amendment 40 in the name of Rhoda Grant. Ready to debate with Amendment 1. Rhoda Grant to move or not move?
Moved.
Moved. The question is that Amendment 40 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 41 in the name of Rhoda Grant. Ready to debate with Amendment 1. Rhoda Grant to move or not move?
Moved.
Moved. The question is that Amendment 41 be agreed to. Are we all agreed?
Yes.
Are we all agreed?
Yes.
The Parliament is agreed. I call Amendment 42 in the name of Rhoda Grant. Ready to debate with Amendment 1. Rhoda Grant to move or not move?
Moved.
Moved. The question is that Amendment 42 be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I call Amendments 7, 8, 9, 10, 11, 12, 13 and 14, all in the name of the Minister and all previously debated with Amendment 6. I invite the Minister to move Amendments 7 to 14 en bloc.
Moved en bloc, Presiding Officer.
Thank you, Minister. Does any member object to a single question? And could I, Mr Whitfield objects. Could I seek clarification from Mr Whitfield which amendment or amendments?
Up to 12 is satisfactory. Up to 12 can be blocked.
Up to 12 can be blocked. Thank you. So what I will do is I will...
The question is that 7 to 12.
So I would say to members that the question is that amendments 7 to 12 be moved en bloc.
No, to be agreed to.
Sorry, the question is rather that amendments 7 to 12 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I now ask if the question is that amendment 13 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division. Members should cast a vote now. Where are you pointing to? The vote is now closed. Point of order, Jenny Gilruth.
Presiding Officer, my app wouldn't have connected. I would have voted yes.
Thank you, Ms Gilruth. Your vote will be recorded. Thank you. The result of the vote on amendment number 13 in the name of Jim Fairley is yes 67, no 36. There were no abstentions. The amendment is therefore agreed. I now call amendment... No, I don't. The question is that amendment 14 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I now call amendment 43 in the name of Rhoda Grant. Already debated with amendment 5. Rhoda Grant to move or not move?
Not moved.
Not moved. I now call Amendment 44 in the name of Rhoda Grant, already debated with Amendment 5. Rhoda Grant to move or not move?
Not moved.
Not moved. I call Amendment 45 in the name of Rhoda Grant. Already debated with Amendment 5. Rhoda Grant to move or not move?
Not moved.
Not moved. I call Amendment 46 in the name of Rhoda Grant. Already debated with Amendment 5. Rhoda Grant to move or not move?
Moved.
Moved. The question is that Amendment 46 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendment 15 in the name of the Minister. Already debated with Amendment 5. Minister to move formally.
Moved.
Thank you. The question is that Amendment 15 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast a vote now. The vote is now closed. Thank you. The result of the vote on amendment number 15 in the name of Jim Fairley is yes 83, no 21. There were no abstentions. The amendment is therefore agreed. I call amendment 16 in the name of Alistair Allen, already debated with amendment 5. Alistair Allen to move or not move? Moved. The question is therefore... No, I've got an amendment. So the question is... I rather call Amendment 16A in the name of Rhoda Grant, already debated with Amendment 5. Rhoda Grant to move or not move?
Not moved.
Not moved. The question is... the question is therefore that...
Alistair Allen to press the withdrawal on
Is he not?
16. He's just moved it now. He's pressed the withdrawal.
Okay, I now ask Alistair Allen to press and withdraw Amendment 16.
Pressed.
Thank you, Dr Allen. So the question is that Amendment 16 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division and members should cast a vote now. The vote is now closed. The result of the vote on amendment number 16 in the name of Alistair Allen is yes 102, no 1. There were no abstentions. The amendment is therefore agreed. I call amendments 17, 18, 19, 20 and 21 all in the name of Alistair Allen and all previously debated with Amendment 5. I invite Alistair Allen to move Amendments 17 to 21 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 17 to 21? No member objects. The question, therefore, is that Amendments 17 to 21 are agreed to. Are we all agreed? Yes. Are we all agreed? No, the Parliament is not agreed. There will be a division and members should cast a vote now. Vote is now closed. The result of the vote on amendment number 7, on amendments numbered 17 to 21 in the name of Alistair Allen is yes 82, no 22. There were no abstentions. The amendments are therefore agreed to. I call amendment 47 in the name of Rhoda Grant, already debated with amendment 5. Rhoda Grant, to move or not move?
Moved.
Moved. The question is that amendment 47 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast a vote now. The vote is now closed. Thank you. The result of the vote on amendment number 47 in the name of Rhoda Grant is yes 22, no 84. There was one abstention. The amendment is therefore not agreed. I call amendment 48 in the name of Edward Mountain, already debated with amendment 6. Edward Mountain to move.
Not moved.
Not moved. I call amendment 49 in the name of Edward Mountain, already debated with amendment 6. I have to read it out. Edward Mountain, move or not move?
Not moved.
Thank you, Mr Mountain. I now call amendment 50 in the name of Edward Mountain, already debated with amendment 6. Edward Mountain, move or not move?
Moved.
Moved. The question is that amendment 50 be agreed to. Are we all agreed? The Parliament is agreed and amendment 50 is therefore agreed to. We now turn to Group 6 on registration requirements. I call amendment 51 in the name of Edward Mountain, grouped with amendments as shown in the groupings, and I call on Edward Mountain to move amendment 51 and to speak to other amendments in the group. Mr Mountain.
Thank you very much, Presiding Officer. I have 5 amendments in this group, 51 to 55. These amendments are about promoting communication between the crofter and the landlord at the point of registration. Presiding Officer, I think we all agree registration of croft is absolutely critical and has been government policy for a while. This is to try and help minimise and make it simpler when it comes to the first registration of crofts and identify any discrepancies at an early stage. The Commission would prescribe a form of notice to be given by a crofter to the landlord, which would include a copy of the application. This would allow the landlord to comment on the application, and I stress the Commission would not be required to act as arbiter, but simply highlight the discrepancies to the keeper of the registers when the croft went through to be registered. The amendments, I do not believe, would add an administrative burden to the Commission, nor put them in the middle of a fight between a landlord and a crofter if such a thing were ever to happen. But it would flush out potential areas of dispute before, as the registration process was going through. This has come about from my experience of trying to register crofts, which has been sometimes quite difficult because the ownership is quite difficult to identify in title deeds. I would just say, Presiding Officer, there are the other amendments in the group, sorry, to be clear, 22, 23, 24, 32 and 33 are minor technical amendments on behalf of the Minister, and I would confirm that on this side of the chamber, we'd be supporting those. So the Minister can talk to them for some length of time if he wishes to, or could just accept our report and allow us to concentrate on amendments 51 to 55. Minister, Presiding Officer.
Thank you, Mr Mountain. I call the Minister to speak to Amendment 22 and other amendments of the group. Minister.
Apologies. I can't support Edward Mountain's amendments 51, 52, 53, 54 or 55. And on the surface, the amendments are quite harmless, but they are either unnecessary or they don't provide any benefit. There is no need for a separate form to be created because this bill provides the same thing in a simpler and more direct way by requiring the crofter to share the draft application with the landlord 21 days in advance, and the draft application includes the map. The Crofting Commission are responsible for drafting and providing the regulatory applications that are used by their customers. They do it for all applications, whether it's for assignations, decroftings, creating a new croft or anything else. In fact, I know that the Commission are already in the process of drafting all the forms necessary for this new provision, which will take into account the requirement, as set out in the bill, that the tenant must give a copy of the draft application to the landlord. When the Commission receives a first registration application, it already checks, in accordance with Section 7(3) of the 2010 Act, the information contained in or accompanying the application against the information relating to the croft in the Register of Crofts. If there is a dispute between the landlord and the crofter, then that should always remain a matter for the Land Court. The Commission and the Keeper do not have the authority or the skills to resolve the registration disputes, and that is one of the reasons why we have a specialised court to deal with crofting disputes, and I know that the member is very well aware of that process. Turning now to my own amendments 22 to 24, they are technical amendments which correct aspects of Section 27G. For consistency with the rest of the bill and for consistency with the aim of that section, that decrofting applications can only be made on register crofts or on a few croft. My Amendment 32 and 33 will ensure that Ariane Burgess' successful amendment at Stage 2, which we supported, that allows the Crofting Commission to consider a review reporting to bring a part of an apportionment to an end, also serves an event that must be registered against a registered croft or common grazing. These two amendments also ensure that the Crofting Commission can treat all the apportionment applications in the same way, by including those made between 1955 and 1993, along with those made under the 1993 Act.
Thank you, Minister. I call Edward Bounton to wind up and to press or withdraw Amendment 51.
Thank you very much, Presiding Officer. I'll keep this short and sweet. I understand what the Minister says. Practical experience tells me that my amendments would be a sensible way forward. So, therefore, all I will say is I will press Amendment 51. If Amendment 51 fails, I will not push Amendment 52, 53, 54 and 55. And this side of the chamber will be supporting the other amendments in the group. Presiding Officer.
Thank you. The question is that Amendment 51 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast a vote now. The vote is now closed. Thank you. The result of the vote on amendment number 51 in the name of Edward Bounton is yes 42, no 66. There were no abstentions. The amendment is therefore not agreed. And notwithstanding what Mr Bounton said, I will nonetheless, in the interest of prudence, proceed to call the following amendments. I call Amendment 52 in the name of Edward Bounton. Ready to debate with Amendment 51. Edward Bounton to move or not move? Not moved. Not moved. I call Amendment 53 in the name of Edward Bounton. Ready to debate with Amendment 51. Edward Bounton to move or not move? Not moved. I call Amendment 54 in the name of Edward Bounton. Ready to debate with Amendment 51. Edward Bounton to move or not move? Not moved, Presiding. Not moved. And I call Amendment 55 in the name of Edward Bounton. Ready to debate with Amendment 51. Edward Bounton to move or not move? Not moved, Presiding. Not moved. I now call Amendments 22, 23, 24 and 25, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 22 to 25 en bloc.
Moved en bloc, President.
Thank you. Does any member object to a single question being put on Amendments 22 to 25? No member objects. The question is that Amendments 22 to 25 are agreed to. Are we all agreed? Yes. The Parliament is agreed. We now turn to Group 7 on Crofting Commission Landlord Representation. I call Amendment 56 in the name of Edward Mountain, grouped with Amendment 57, and I call on Edward Mountain to move Amendment 56 and speak to both amendments in the group. Mr Mountain.
Thank you, Presiding Officer. These two amendments in my name are the only ones in this group, and this is to do with the representation of landlords' interests on the Crofting Commission. Just before anyone wants to question this, I am not a landlord and I have no landlord's interest. I am just purely a tenant and not a tenant of a Croft. Currently, the interests of the landlords must be represented on the Commission, but the bill as drafted would remove that obligation. I just make this gentle comment. Every croft has a landlord, unless it's an owner-occupied croft, and it still has a landlord technically within the law. But I note that the bill does not remove the provision of Gaelic speakers represented on the Commission, despite the fact that only 130,000 people speak Gaelic in Scotland. That's 2.5% of the population. I'm not disputing the importance of Gaelic language in the Crofting communities. I think it's a fundamental protection of the language and a fundamental protection of some of the rural populations, which I feel very strongly about. However, my Amendment 56 would reverse the removal of the landlord representation on the Commission, reinstating the status quo. If that was unacceptable to the Minister, I will. Can I just finish this and then I'll come back to you, Mr Allen? My Amendment 57 would provide an option that if 56 was not agreed, it would enable, without forcing the Commission to co-opt a member who represents the interests of landlord. I'll give way to the presiding officer at that stage.
Will the member acknowledge that there are only 11 commonly used irregular verbs in Gaelic, and if a landlord wishes to become the Gaelic speaking representative, he or she need only learn?
Edward Mountain.
Well, I won't fall into the temptation to say that that may prove too difficult for some landlords. But what I would just say is that, as we well know, and Dr Allen knows, presiding officer, the current representative that represents landlords' interest is also a Gaelic speaker. So it is dual-hatted. I very much take that point. But I think the point is that what I'm trying to do is make sure there's an equilibrium between the two. And the very point of it, presiding officer, is that it is absolutely vital, as I made earlier, that common grazings are used by crofters to ensure that this country meets its net zero obligations, not only in peatland restoration but woodland planting. Having a landlord's representative on the Commission would ensure there was no conflict. I would just say, in closing, presiding officer, that giving the Commission the flexibility to do it would be helpful. Now, I know, the presiding officer, that the Minister will say, well, he can co-opt one under the legislation, i.e. a representative onto the Commission. I want to take it out of the Minister's hands, put it in the Commission's hands, because I'd like to see that's where the power is, at the Commission level, rather than the ministerial level. I wait to hear the Minister's comments, presiding officer.
Thank you, Mr Mountain. I call Rhoda Grant.
I just want to make a couple of comments about this. I don't agree with those amendments. Until the last legislation changed it, the Crofting Commission used to be the Crofters Commission and belonged to the crofter to uphold their rights. And I think putting landlords on the Commission as a par for the course is not helpful, be they a Gaelic speaker or not. I think the Commission should represent the power and balance between the relationship between the crofter and the landowner.
Thank you. I call the Minister.
Thank you very much, Presiding Officer. I cannot support Edward Mountain's Amendments 56 and 57, but I do recognise the importance of the landlord's interest being represented. And the bill continues to recognise this in the paragraphs that Mr Mountain wants to remove. However, with only 3 appointed commissioners to the board, and appointments only made every few years, the Commission needs the flexibility and is asking for flexibility when it comes to selecting the strongest overall mix of skills and experience. And that is what the bill does. It provides the Scottish ministers must consult the Commission on the desired attributes before appointing a new member, while also having regard to the value of a commissioner who can represent the landlord's interests. This approach gives proper weight to the landlord voice without constraining the Minister's ability to make the best appointment for the Commission as a whole. In addition, I can reassure Mr Mountain that the Commission is more than willing, in fact I would expect them, to formalise a relationship between itself and those organisations that represent landlords, and that they are happy to have a dedicated Commissioner that will consult with them on any relevant matters and then feed that back to the Board at a strategic level. The Scottish Government supports that initiative, which will ensure that the whole Board gains a better understanding of the landlord's perspective. And as Mr Mountain pointed out, the 1983 Act gives ministers the power to increase the number of members to the Commission Board, which it could use to fill any skills gaps if that was required. So I'd urge Mr Mountain not to press these amendments, and if he does, I ask members not to support them.
Thank you. And I call Edward Mountain to wind up and press or withdraw Amendment 56.
Thank you very much, Presiding Officer. I've listened carefully to what the Minister says, and it does give me some confidence. However, I just make this small observation, if I may, Presiding Officer. Crofting commissioners are paid £10,812 a year for working 4.5 days per month. The additional commissioner, if decided was required, would not add overly to the bill. The Minister has previously highlighted and has done today that paragraph 3.6 of Schedule 1 of the Crofters Scotland Act 1993, one of the many acts that cover crofting, and my goodness, you need to know your way around them, gives the Minister the ability to co-opt an additional member. I would rather that was in the hand of the Crofters Commission, so they have the flexibility to try and make sure that crofting went from strength to strength. I will not move Amendment 56. However, I will move Amendment 57, Presiding Officer.
Thank you. Edward Mountain seeks to withdraw Amendment number 56. Does any member object? Amendment 56 is withdrawn. I call Amendment 57 in the name of Edward Mountain, already debated with Amendment 56. Edward Mountain, to move or not move?
Move, Presiding Officer.
Thank you. And the question is that Amendment 57 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. I call Marie Todd for a point of order.
Thank you, Presiding Officer. I would have voted no.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 57 in the name of Edward Mountain is yes 25, no 80. There were no abstentions. The amendment is therefore not agreed. We move to Group 8, Review of Crofting Legislation. I call Amendment 26 in the name of the Minister, grouped with Amendment 26A. Minister to move Amendment 26 and speak to both amendments in the group.
Thank you very much, Presiding Officer. Presiding Officer, I agree with members right across the chamber that future reform of crofting will be absolutely necessary. The last 4 years of stakeholder engagement and consultation have been incredibly informative, and we now have a bill that has wide stakeholder input and buy-in. However, these discussions have also shown us that there is a diverse range of views within the crofting sector. That is why, following discussions with stakeholders and members from all parties, I propose that we carry out a new review of crofting legislation. In order to assess the effectiveness of the legislation, we need to be clear of what it is that we want to deliver. Therefore, we all, including stakeholders, need time to consider what crofting policy should be in the future. We are committed to working closely with the stakeholders, crofters, landlords and everyone else involved in the sector, and building consensus and finding solutions which will stand the test of time, because that is what we need to do. Establishing clear policy outcomes will take time and will be central to a future wholesale reform. This review will include the 1993 and the 2010 Acts, and it will also include a review of this Act. So by requiring the review to be started within 3 years at the latest, it allows this bill a period of time to bed in for its full impact and effectiveness to be measured and assessed, including the full impact of the many changes that the Crofting Commission are planning to make to their policy plan and their approach to enforcing regulatory duties. I think it's right that we allow up to 3 years for an incoming government to decide its approach, but I also want to put on record that if my party is in government, we will commence the review within 2 years of royal assent, well ahead of that 3-year deadline, and seeking to build on the engagement that we have carried out during this term. I hope that that provides members with the reassurance that they need as regards my party's ongoing commitment to crofting reform, and I'll take Edward Mountain's intervention.
Edward Mountain.
And I thank the Minister for giving way on that. I remember when I first came into this Parliament in 2016, we started looking at crofting reform. And it was agreed that crofting reform wasn't just about crofting. It was about keeping the population in the crofting areas, providing a sanctuary for language and for people on the land. Could I just confirm that when the review is being carried out of the legislation, of which there are numerous acts, too numerous to mention, that it will first of all detail what the aims of crofting should be for the future? Because if we don't set out the aims, we won't be able to protect it and make sure it thrives for many years to come.
Minister.
I'm very glad that Edward Mountain puts that on the record, because he's absolutely right. Crofting is about people, it's about culture, it's about history, it's about what the future of Scotland looks like. And for me, any review of crofting has to take all of those things in the round and make sure that what we're delivering is what the people of Scotland and the crofting communities want. And that's what that review should be about. So turning to Rhoda Grant's Amendment 26A, that would require the review to start within 12 months of royal assent, I would worry that that could prove too soon after the extensive changes that we've made in this bill. That's why I'm asking that Rhoda Grant supports my Amendment 26, but she doesn't press Amendment 26A to allow the bill that we've currently got in front of us to bed in and then do a proper review so that we know exactly where we stand and where it is that we're trying to go. Thank you, Presiding Officer.
Thank you. I call Ariane Burgess. My apologies. In a moment, Ms Burgess. I call Rhoda Grant to move Amendment 26A and speak to both amendments in the group.
Thank you, Presiding Officer. My concern is that Amendment 26, as it's drafted, it will require a report after 3 years, and this would limit any practical chance of bringing forward new crofting legislation. I've heard what the Minister has said about allowing this bill to bed in, but we all know there are huge gaps in this bill. This bill is really about administration and not the future policy surrounding crofting. And as he acknowledged himself, there's agreement across the industry stakeholders and indeed I think most political parties that crofting needs new law and it needs to be modified at a pace. This bill was promised not this Parliament, but at the last Parliament, and had waited until the very end of this Parliament to come forward, not really making changes in policy. So therefore, I'm looking to change the reporting period to 12 months. Yes.
Minister. I absolutely hear the point that Rhoda Grant is making to me, but in that entire period of time, bearing in mind the bill that we have in front of us has been 4 years of work ongoing from when that was started. And the provision that is in this amendment, it says up to 3 years. That's a backstop. So the review will be started within that 3-year period. And I would very much hope that if we come back into government, we will start that within 2 years. But we've got to get it right. We've got to allow the bill that we've got currently to bed in, to allow people to see how this is going to work, and then work out what it is that we're going to go and do forward. And that's a commitment that we will give, because I hope that this bill is demonstrating that we are laying out that we take this seriously, and we want to make sure that we put a firm future for crofting in Scotland by making sure we get it right in the first place.
Rhoda Grant.
I absolutely agree that it has to be got right, because part of this bill is putting right some of the wrongs that happened before. So with that reassurance, I won't seek to press my amendment 26A.
Can I just ask Ms Grant that you move the amendment at this point? We will come back to it.
Okay, I'll move it at this point.
Thank you. I call Ariane Burgess.
Can I just clarify, did Rhoda Grant move the amendment? Yes. Yeah, okay. I'd like to express my thanks to the Minister for taking on board the amendments brought by myself and Tim Eagle at stage 2 and amalgamating them into Amendment 26. It's vital that the next Government and Session 7's cohorts of MSPs take a deep look at what we've got in crofting legislation at present, how we can tackle the big issues facing the crofting community, and how the existing body of legislation can potentially be streamlined and simplified. In fact, I've just been having a chat with my colleague Gillian Mackay about an anomaly in Brora, and these are the kinds of things that we need to address. So I urge the Scottish Government to front-load key issues in this piece of work, topics like common grazings and crofting tenancies. The 3-year time limit for getting this work underway is reasonable, which is why I am also concerned. I hear Rhoda Grant's points about wanting it to happen sooner, but I take on board the government's points around needing to really get deep into this work and unravel a whole lot of issues. To that, I'm not minded to support Rhoda Grant's Amendment 26A.
Thank you. I call on the Minister to wind up on Amendment 26.
Nothing more to say, and move, I think.
Thank you. I call Rhoda Grant to wind up and press or withdraw Amendment 26A.
Can I withdraw 26A?
Thank you. Rhoda Grant seeks to withdraw Amendment 26A. Does any member object? No member objects, and Amendment 26A is withdrawn. And Minister, to press or withdraw Amendment 26.
Moved. Pressed.
Thank you. And the question is that Amendment 26 be agreed to. Are we all agreed? We are agreed, and we move to Group 9, Land Court Reviews and Guidance. I call Amendment 28 in the name of Ariane Burgess, grouped with Amendment 27. Ariane Burgess to move Amendment 28 and speak to both amendments in the group.
I move Amendment 28. Thank you, Presiding Officer. The merger of the Scottish Land Court and the Lands Tribunal for Scotland is welcome. It will bring greater clarity and consistency to how land-related matters are handled. As part of these changes, access rights matters will transfer from the Sheriff Courts to the merged court. This amendment supports that transition. It will ensure that before the transfer of jurisdiction happens, guidance issued under Section 27 of the Land Reform Scotland Act 2003 will be updated so that it reflects the Scottish Land Court's new role. While I accept that the Government would naturally update this guidance in due course, I feel it's important to place a clear legal requirement on ministers to do so. Local authorities and others who rely on the guidance need certainty that it will be revised at the right time. So this amendment will help ensure a smooth and well-understood transition. Turning to the other amendment in this grouping, number 27, in the name of Jim Fairley, I think it's prudent of the Scottish Government to commit to a review of how the merged land court is getting on. I'm especially pleased that this amendment will require ministers to assess whether further areas of environmental law may be suitable for transfer to the court, and to communicate that assessment to this chamber. I believe this amendment will make a clear case for what I called for at stage 2 of the bill, that we should enable the Land Court to become an environmental court, and I move Amendment 28.
Thank you. I call on the Minister to speak to Amendment 27 and other amendment in the group.
Thank you very much, Presiding Officer. I'd like to thank Ariane Burgess for proposing and explaining Amendment 28, because access rights matter and transfer to the merged Scottish Land Court, and I agree it is essential that the support and guidance properly reflects the new arrangements. The Government would, of course, update the Section 27 guidance as part of implementing these changes. However, I recognise that this amendment ensures that the update happens in advance of the new jurisdiction taking effect, allowing those who use the system to be ready for the change. Excuse me. For this reason, Scottish Government is happy to support Amendment 28. At Stage 2, Ariane Burgess and Tim Eagle both brought forward proposals seeking a review mechanism. I appreciate the points that they raised, and this amendment responds directly to those concerns by putting a clear and structured review duty on the face of the bill. And Amendment 27 provides a statutory mechanism to review the effect of the merger of the Scottish Land Court and the Lands Tribunal for Scotland. Importantly, before any review is carried out, there is a safeguard for judicial independence with a requirement to consult the Lord President. This will ensure that judiciary's perspective is properly considered as this work is undertaken. This amendment requires Scottish ministers to review each new area of jurisdiction 3 years after it comes into force, and I believe that that provides the right amount of time for the changes to bed in and for evidence to emerge about how the new arrangements are working. A key element is ensuring that the judicial, operational and user experience is fully reflected in the process, and the framework provides that insight to be drawn upon as part of each review. That will help to identify whether any refinements are needed to support the effective operations of the court. In line with the policy intention of the court's remit may develop over time, ministers must also assess whether any further areas of environmental law may be suitable for transfer into the court's jurisdiction. Following a review or assessment, a report must be prepared and laid before Parliament and published, setting out the findings and whether any legislative changes are proposed. Taken together, the provisions create a proportionate and evidence-based framework for monitoring how the Court's expanded jurisdiction is operating and for informing any future development. And I invite members to support Amendment 27.
Thank you. And I call Ariane Burgess to wind up and press or withdraw Amendment 28.
Nothing further to add, and I press Amendment 28.
The question is that Amendment 28 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division, and members should cast their votes now. The vote is closed. The result of the vote on amendment number 28 in the name of Ariane Burgess is yes 82, no 24. There were no abstentions. The amendment is therefore agreed. I call Amendment 27 in the name of the Minister, already debated. With Amendment 28, Minister to move formally.
Move, Presiding Officer.
Thank you. The question is that Amendment 27 be agreed to.
28. Oh, sorry, 27. Sorry.
The question is that Amendment 27 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendments 29, 30, 31, 32 and 33, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 29 to 33 en bloc.
Moved on lot.
Thank you. Does any member object to a single question being put on Amendments 29 to 33? No member objects. Therefore, the question is that Amendments 29 to 33 are agreed to. Are we all agreed? Yes. We are agreed. That ends consideration of amendments. And as members know, I am required under standing orders to decide whether or not, in my view, any provision of a bill relates to a protected subject matter. That is whether it modifies the electoral system and franchise for the Scottish parliamentary elections. And in the case of this bill, in my view, no provision of the Crofting and Scottish Land Court Bill relates to protected subject matter. Therefore, the bill does not require a supermajority to be passed at stage 3. And I'll just allow a moment or two for front benches to organise before we move to the next item of business.